Number 1. David Chiselton. Aaron Brockler had just listened as his client was sentenced to 47 years in prison. He turned to reassure him, to tell him he would visit and that they would look at their options. He never even got the chance. The next thing he remembers is waking up on the floor beneath the courtroom table. The man who had just knocked him unconscious was his own client, David Chiselton. How David Chiselton ended up in that courtroom goes back to April of 2017, to a Warrensville Heights apartment complex, and a night that left 16 families without a place to sleep. Warrensville Heights is a small suburb just southeast of Cleveland, Ohio. David Chiselton was 42 years old and lived there with his girlfriend at the Miles Landing apartment complex on Banbury Court. By all accounts, the relationship was troubled. There were accusations that Chiselton had been sexually abusing his girlfriend's teenage daughter. And on the afternoon of April 10th, 2017, things finally came to a head. An argument broke out around 2 in the afternoon. At some point, Chiselton pulled out a gun, pressed it against his girlfriend's head, and told her she was going to die that night. He pistol whipped her. He threatened to kill her and her daughter, but somehow his girlfriend managed to break away. She ran to a neighbor's house and called 911. When police arrived, Chiselton refused to come out. He barricaded himself inside the building. Officers tried to talk him out, but he wasn't interested. The Valley Enforcement Group SWAT team was called to the scene. And then, around 3 in the afternoon, before anyone could get to him, Chiselton set fire to the second floor of the building. The flames spread fast. High winds pushed the fire through the complex and into the building next door. By the time firefighters got it under control, the entire structure was destroyed. 16 families had nowhere to go. The city of Warrensville Heights and the American Red Cross scrambled to find them shelter. Some were put up in hotels. Dozens of children were among those displaced. SWAT eventually got Chiselton out of the building and took him into custody. His ex-wife, Florine Chiselton, later told reporters that she was able to escape before the fire started and was with police by the time it broke out. Chiselton was charged with nearly 24 counts: aggravated arson, felonious assault, domestic violence, unlawful sexual conduct with a minor, cruelty against a companion animal, and more. His bond was set at $1 million. Over the following months, as the case moved through the court system, Chiselton eventually pleaded guilty to the charges. And on the morning of February 19, 2019, he was brought to courtroom 18C at the Justice Center in downtown Cleveland for sentencing before Judge Nancy Margaret Russo. His defense attorney was a man named Aaron Brockler, a Cleveland lawyer who had been in Chiselton's corner throughout the entire case. He was standing next to his client when Judge Russo handed down the sentence: 47 years. The moment that sentence landed, Chiselton snapped. He turned to his left, where Brockler stood beside him, and sucker punched him twice in the head. Brockler went down immediately. Brockler describes what happened from his perspective. He says he had turned toward Chiselton to tell him he would come visit him privately to discuss what options they had to potentially reduce the sentence. Before he could even open his mouth, he heard a swoosh sound, and then everything went black. He woke up on the floor underneath the courtroom table. He had no memory of going down. When he regained consciousness, he saw officers on top of his client trying to restrain him. What he didn't know yet was that after knocking him unconscious, Chiselton had also bitten him on the leg before deputies could pull them apart. Assistant Cuyahoga County Prosecutor Jeff Schnatter physically got involved in the chaos, dragging Brockler away from Chiselton by his foot. Brockler was taken out of the courtroom on a stretcher. He was treated at a nearby hospital for a broken nose and a severe concussion. He later joked that leaving on a stretcher was pretty fun. Chiselton faced a new charge for the attack: felonious assault, and the case went to trial in October of 2019. But here is where the story takes a turn that nobody quite expected. Chiselton's new defense attorney, a man named Jim Jenkins, stood up in front of the jury and argued that Brockler's injuries simply didn't meet the legal standard for felonious assault in Ohio. The charge required proof of serious physical harm, and Jenkins argued that 2 hairline fractures to the nose didn't clear that bar. He told the jury, directly, David Chiselton doesn't pack much of a punch. Jenkins also raised something else. He told the jury that Chiselton had been screwed by the system, and he aired Chiselton's claim that Brockler had promised him before sentencing that he would use his personal friendship with Judge Russo's husband to get the sentence down to as little as 9 years. The jury acquitted Chiselton of felonious assault. Had he been convicted, He could have faced an additional 8 years on top of the 47 he was already serving. Instead, a judge ordered him back to prison to continue his existing sentence. Brockler posted on Facebook the following day. He wrote that he disagreed with the jury's verdict but respected it. And then he said something that stayed with a lot of people who followed this case. He said, "People think they can get away with treating their attorneys like this and showing that disrespect. It was just a broken nose, but there's a lot more collateral damage that a situation like that causes." As for David Chiselton, he is currently serving 47 years in an Ohio prison. Number 2, Taylor Shabus. Taylor Shabus had just been arrested for killing and dismembering a man she had known since high school and had a sexual relationship with for years. When detectives brought her in, she didn't even flinch. She told them the police were going to have fun trying to find all his remains. She told them to check the basement, and at some point during that conversation, she asked the detectives a question. She wanted to know if they understood what it was like to love something so much that you kill it. That was February of 2022. By the following year, Taylor Shabus would be sitting in a Wisconsin courtroom, restrained, handcuffed, and waiting for a routine hearing. And what she did next is something nobody in that room, including the man sitting right beside her, saw coming. The story actually starts with a man named Shad. Shad Therian was 24 years old and lived in Green Bay, Wisconsin. He and Taylor had known each other for years, all the way back to high school. By early 2022, they were still in each other's lives, the kind of complicated situationship that never quite becomes a real relationship but never fully goes away either. Taylor was 24 and her life was already falling apart before any of this happened. Just weeks before the murder, back in January of 2022, she was convicted of fleeing and obstructing police and sentenced to 3 months in jail. Whether she was on some kind of work release when things went wrong with Shad was never fully confirmed. The night of February 21st, 2022 started out like a lot of nights probably did for Taylor and Shad. She picked him up from his mother's house. His mother, a woman named Tara Pakanich, was away that night with her boyfriend Steve Hendricks, so the place was empty. Taylor and Shad, along with a friend, drove over to an apartment on Eastman Avenue. They hung out for a while, smoked some cannabis. At some point, the friend left. And then, according to what Taylor told investigators herself, she and Shad smoked methamphetamine and injected trazodone before heading back to his mother's house. They went down to the basement and things started out the way they apparently always did between the two of them. Taylor later told investigators that she and Shad had done erotic asphyxiation before, that it wasn't the first time. But that night, they used metal chains. Somewhere in the middle of all that, Taylor began to strangle him. She said he started coughing up blood. Instead of stopping, she kept going. For 3 to 5 minutes, she continued until Shad Therian was dead. What happened next changed this case from a terrible crime into something far worse. Taylor stayed in that basement with Shad for several hours and desecrated his body. Then the following morning, she went through the house, found knives, and came back downstairs. She spent that morning dismembering him, packing his remains into bags and boxes, and loading everything into her gold Town and Country minivan before she left. Shad's mom came home in the early hours of February 23rd. She heard the front door close, went downstairs to check on her son, and found his head in a bucket, covered with a towel. Her boyfriend, Steve, called the police. When officers got to the house and searched that basement, they found what was left of Shad Therian stuffed into bags and boxes throughout the room. Taylor was picked up later that same day at the Eastman Avenue apartment. Her clothes were covered in blood. She had a cut on her left thumb and scratches on her arms that she claimed she had done to herself. And when detectives sat down with her, she was calm. She told them to check the basement, told them the police were going to have fun finding everything. At one point, she asked them if they knew what it was like to love something so much that you kill it, and then she told them she had enjoyed it. She was formally charged on March 1st with first-degree intentional homicide, abuse of a corpse, and third-degree sexual assault. Her bond was set at $2 million cash. A public defender named Quinn Jolly was assigned to represent her, and right away, Jolly had a complicated hand to play. Taylor wasn't denying she killed Shad. That was never really the dispute. The question was whether she could be held fully legally responsible for what she'd done. In September of 2022, Jolly entered a not guilty by reason of mental disease or defect plea on her behalf. That's Wisconsin's version of an insanity defense. The argument was essentially that, Whatever state Taylor was in that night meant she couldn't fully understand that what she was doing was wrong. On top of that, there was a separate legal question running alongside the insanity defense. The question of whether Taylor was even competent to stand trial in the first place. In a legal sense, competency has nothing to do with guilt or innocence. It just means, can this person understand what's happening in that courtroom? And can they actually help their own attorney put together a defense? And in Taylor's case, that question dragged on for months and kept pushing the trial back. By early 2023, a trial date was finally set for March 6th, but Jolly was still waiting on a second expert's report about Taylor's competency, and that report wasn't ready yet. So on the morning of February 14th, 2023, Jolly walked into Brown County Circuit Court, stood before Judge Thomas Walsh, and asked for 2 more weeks. Judge Walsh wasn't happy about it, but he agreed. He pushed the trial to May 15th. Taylor Shabus was sitting right next to Quinn Jolly when the new date was announced. And then out of nowhere, without any warning at all, she lunged forward and drove her elbow straight into him. A deputy tackled her to the ground before she could do any more damage. When deputies finally got her restrained and started dragging her out of the room, Taylor Shabus looked over at a family member in the gallery and gave them a little wave, like she was just heading out early from a party. Back inside the courtroom, once things settled down enough to continue, Quinn Jolly leaned into his microphone and told Judge Walsh he was done. He was withdrawing from the case. 2 weeks later, on February 27th, a formal hearing was held to deal with Jolly's withdrawal request. 2 armed deputies stood within arm's reach of Taylor the entire time, close enough to grab her the second anything happened. Jolly filed his motion, and the language he used was precise and deliberate. He wrote that the attorney-client relationship had become irretrievably broken as a direct result of what Taylor had done in that courtroom on February 14th. He said he believed withdrawal could happen without hurting her case or the state's case, and he asked to be released from all further representation. The Wisconsin State Public Defender's Office managed to find new representation for Taylor within 2 weeks. The new attorney was a man named Christopher Froelich, and he would be the one standing next to her when the real reckoning finally came. The trial started in July of 2023. It ran in 2 phases, the first to determine guilt, the second to determine whether Taylor's mental state at the time of the murder meant she should be held criminally responsible for it. During the first phase, the prosecution laid out exactly what had happened on Stony Brook Lane. They played the police call in which Tara Pakinich and Steve Hendricks reported finding Shad's head. The prosecution's closing argument was blunt. Assistant District Attorney Caleb Saunders told the jury there was one truth in this case: what Taylor Shabus did to Shad Therian. He walked them through every decision she made that night. The meth, the chains, strangling him after he started coughing blood, what she did to the body afterward, the dismemberment, loading the minivan. Every single one of those, he argued, was a choice. The jury deliberated for about an hour before coming back with a guilty verdict on all 3 counts. First-degree intentional homicide, mutilating a corpse. Third-degree sexual assault. The following day, in the second phase of the trial, the same jury deliberated for roughly another hour before unanimously finding that Taylor Shabus did not have a mental disease or defect that affected her ability to know right from wrong when she killed Shad Therian. Her insanity defense was gone. Sentencing came on September 26th, 2023. Taylor showed up to court wearing a spit hood because she had been spitting on jail staff and the sheriff's office wasn't taking any chances. When Judge Walsh asked if she had anything she wanted to say before he handed down her sentence, she looked at him and said, "No, there isn't." Christopher Froelich, her attorney, told the court she was 25 years old and there was still time for rehabilitation. He said she was not a monster. Judge Thomas Walsh sentenced her to life in prison without any possibility of parole, plus additional consecutive time for the dismemberment and sexual assault charges. She was sent to Taichita Correctional Institution in Fond du Lac, and if anyone thought that environment would settle her down, they were wrong. In July of 2024, Taylor got a staple lodged in her arm from a fall and was taken to the prison medical room. A nurse came in to remove it. And according to the criminal complaint that followed, Taylor was giggling the entire time. The nurse warned her it might hurt a little and moved in with the tweezers. That's when Taylor shoved her out of the way and lunged at her. When the sergeant stepped in to break it up, Taylor grabbed a small metal table and swung it at her. The sergeant eventually subdued her with pepper spray. and was later taken to the hospital for her injuries. That charge, battery by a prisoner, meant Taylor needed a lawyer again. A public defender named Curtis Julka was assigned to represent her. And in April of 2025, during a preliminary hearing in Fond du Lac County Court, Taylor Shabus stood up, started yelling, and lunged at Curtis Julka, making him the second defense attorney she had physically attacked in a courtroom. 5 deputies tackled her, pinned her down, and carried her out of the room by her arms and legs. Julka asked to withdraw. The judge made him finish the hearing first, then said he could file the request after. The prison guard case eventually resolved in December of 2025. Taylor pleaded guilty to a reduced charge of disorderly conduct and was sentenced to 90 days in jail, to be served after her life sentence. As of the end of 2025, Taylor Shabus is serving life without parole at Taycheedah. Her court-appointed appeals attorney reviewed her murder conviction, found no grounds for an appeal, and was dismissed from the case. The Wisconsin Court of Appeals told her that if she wants to keep fighting, she'll need to find her own attorney or file her own paperwork. Number 3. Joseph Zeer. Joseph Zeer walked into that Lee County courtroom on the morning of his sentencing with the word "killer" written on his teeth. And what he was about to do in that courtroom would make his death sentence the easiest decision that judge ever had to make. How he got there is a story that starts 33 years earlier, in a Cape Coral apartment, on a night that a mother has never been able to forget. Her name was Jan Cornell, a single mother living in Cape Coral, Florida. She had 2 daughters. Her older daughter had just moved out for college, leaving Jan with her younger daughter, 11-year-old Robin. In May of 1990, Jan got a new roommate. Her name was Lisa Story, 32 years old, a coworker and close friend. Lisa moved in just one day before everything fell apart. She was engaged to be married to a man named Randy Richards. She recently bought him a Seiko watch as a birthday gift and had it inscribed with a personal message and was waiting for the right moment to give it to him. On the evening of May 9th, 1990, Jan went out to her boyfriend's house for the night. She left Robin in Lisa's care, who agreed to watch her. The apartment at the courtyards of Cape Coral condominiums on Southeast 12th Avenue was quiet. There was no reason for anyone to worry. Sometime in the early hours of May 10th, Joseph Zeer entered that apartment through the sliding glass door at the back. What he did inside that apartment that night is almost impossible to put into words. He sexually assaulted and suffocated both Robin Cornell and Lisa Story. He then went through the apartment, stole Lisa's driver's license, her credit cards, her checkbook, and the inscribed Seiko watch meant for her fiancé. And before he left, in what investigators would later describe as a deeply disturbing detail, he took photographs of Robin and her older sister from the living room and carefully arranged them on an ironing board in the kitchen. Then he walked out and disappeared. Jan Cornell came home the next morning. She found the front door double bolted. She had asked Lisa not to use the bottom lock because she only had a key to the top one. She went around to the back. The sliding door was wide open. She stepped into the kitchen and found Robin's photos arranged on the ironing board. She ran upstairs. She found Lisa Story's body on the bed. At first, she thought she was asleep. She ran to Robin's room. Her 11-year-old daughter was lying on the floor. She was cold to the touch. Jan called 911 and tried to revive her, but it was too late. Both Robin Cornell and Lisa Story had been sexually assaulted and smothered. Investigators collected DNA from the crime scene and began the search for whoever did this. The search would take 26 years. Police worked the case relentlessly. They went through hundreds of leads. They brought in new investigators as old ones retired, but the trail stayed cold. And while all of that was happening, Joseph Zeer was living his life just across the river in North Fort Myers, about 20 miles from the apartment where he had done what he did. He was 53 years old. He had been there the entire time. Then he made a mistake. In August of 2016, Zeer got into a violent argument with his 25-year-old son Zachary. It escalated to the point where Zeer pulled out a pellet gun and shot his own son hard enough to break the skin on his chest. Zachary's girlfriend drove him to Lee Memorial Hospital, where he was treated and survived. Zeer was arrested and charged with felony aggravated battery. That arrest is what ended everything for him. Under a Florida law passed in 2009, anyone arrested for a felony is required to submit a DNA sample. That sample goes into CODIS, the FBI's national DNA database. Zeer's sample was submitted as routine, and within days, the Florida Department of Law Enforcement came back with a result that stopped investigators cold. His DNA matched evidence collected from the 1990 crime scene. Cape Coral Police Chief David Newlin held a press conference and said 3 words that Jan Cornell had been waiting a quarter century to hear. "We got him." According to Zeer, he couldn't remember anything from around the time of the murders because of a motorcycle accident that had affected his memory. He was charged with 2 counts of first-degree murder, 2 counts of sexual battery, and 1 count of burglary with assault. His bond was set at $500,000. The case that had haunted Cape Coral for over 2 decades was finally going to trial. The trial took place in May of 2023, 33 years after the murders. Zeer was 61 years old. He had 2 defense attorneys, Kevin Shirley and Lee Hollander. The prosecution's case rested heavily on the DNA evidence, which Zeer's defense tried to challenge at every turn. But then Zeer took the stand, and what he said was something nobody in that courtroom was prepared for. He looked out at the jury and told them that his DNA was at the crime scene because he had been in a sexual relationship with Jan Cornell, Robin's own mother, in the months before the murders. He said he thought the only way his DNA could have gotten there was from sleeping with her, and if that wasn't enough, he called her a pig, right there in open court, with Jan Cornell sitting just feet away. The jury deliberated for about 3 hours. They came back guilty on both counts of first-degree murder. The penalty phase followed. The state presented 4 aggravating factors: that the murders were cold, calculated, and premeditated, and that they were carried out in a heinous, atrocious, and cruel manner. The jury deliberated for about 5 hours. 10 out of 12 jurors recommended the death penalty. And then came June 26, 2023, the day the judge would decide Zeer's fate. Before the formal sentence was handed down, there was a morning motion hearing. Zeer was back in court hoping to get the conviction overturned and a retrial granted. He came in shackled at the wrists, wearing an orange jumpsuit. He demanded that officials take down the cameras, and he had the word "killer" written on his teeth. Seconds after entering the courtroom, Zeer motioned to his defense attorney, Kevin Shirley, acting like he wanted to say something privately, something he didn't want the microphones to pick up. Shirley leaned in. In that instant, Zeer drove his elbow up from behind his back, where his hands were shackled, and slammed it into Shirley's face. 2 bailiffs immediately tackled Zeer to the ground. He was further restrained and removed from the courtroom. As they brought him down, he said he was sorry he missed. Shirley took a seat. The judge asked if he was all right. He looked up and said, "I used to box. I've taken a lot better shots than that one." The motion for a retrial was denied, and hours later, Judge Robert Banning sentenced Joseph Zeer to death, twice. Once for Robin Cornell, once for Lisa Story. Number 4. Lamont Payne. Vladimir Gajic had been a criminal defense attorney for over 20 years. He has represented difficult clients in difficult cases, and he told reporters that in all that time, the idea that one of them might punch him in the face had never once crossed his mind. Not even for a second, until 2018. The man who threw that punch at Gajic was Lamont Payne, and he'd been in trouble long before any of this. Payne has a long history with the criminal justice system, a lengthy record of assaults and disobeying orders, according to Maricopa County court documents. And the case that brought him to that courtroom in 2018 started 2 years earlier, inside a county jail. The 4th Avenue Jail is one of the main detention facilities in Phoenix, Arizona, run by the Maricopa County Sheriff's Office. In 2016, corrections officers came to remove Payne from his cell. He didn't just resist, he made it as difficult as possible. According to court documents, Payne covered the windows of his cell to block the officer's view. He poured soapy water on the floor to create a hazard. And when officers finally managed to get inside and get to him, Payne got down on the ground and bit one of them in the ankle. He was charged with assaulting a corrections officer. And that charge is what brought Vladimir Gajic into the picture. Gajic was a contract attorney working for Maricopa County Public Defense Services, essentially a private lawyer hired by the county to handle cases that the public defender's office needed outside help with. He was assigned to represent Payne and spent significant time preparing for the trial. He later said that in over 20 years of criminal defense work, he had handled all kinds of clients in all kinds of situations. Lamont Payne was a different kind of challenge from the start. Court documents confirm that Payne has a documented history of firing his attorneys and being disruptive in court long before any of this happened. He was not an easy client, but Gajic showed up anyway, did the preparation, and walked into Maricopa County Superior Court for the first day of jury selection in 2018. Jury selection is exactly what it sounds like. The process at the beginning of a trial where both sides question potential jurors to decide who will sit on the panel that decides the case. But it is also the moment when a defendant first gets to sit in a courtroom and see how things are going to go. And for Lamont Payne, things were not going the way he wanted. He started getting restless almost immediately. But underneath all of that, there was something specific bothering Payne. He felt like his attorney wasn't speaking up for him. He wrote questions down on pieces of paper and slid them across the table to Gajic, questions he wanted raised during jury selection. And Gajic wasn't raising them. Payne kept trying to get Gajic's attention. He knocked on the desk. Gajic was looking at the judge and didn't respond. Payne raised his hand to try to get the judge's attention directly. The judge noticed and warned Payne that if the outbursts continued, he was going to be removed from the courtroom. Payne kept talking anyway. He said it out loud for everyone in that room to hear. "My lawyer ain't going to speak up. It's plain and simple. I have been giving him questions, and he is not going to speak up." The judge had seen enough. He ordered deputies to remove Payne from the courtroom. Payne began gathering his papers as deputies walked toward him. And Gajic was looking the other way, completely unaware of what was coming. Payne turned, cocked back, and landed a punch directly to Gajic's face with his right hand. Gajic's description of that moment is one of the most striking things about this whole story. He told reporters he didn't feel any force or pain. The very first thing he noticed was a salty taste in his mouth. He said, "The first thing, literally the first thing I know is, oh, it's salty. I could literally taste his knuckles. Then I got up and checked my teeth. His teeth were all still there. His nose was bleeding and his face was starting to swell, but other than that, he was fine." In the aftermath, Payne was no longer allowed to set foot in a courtroom. Every future court appearance would have to be done remotely via video link. And in May of 2019, Payne pleaded guilty to assaulting Gajic, adding yet another assault conviction to a record that already had several. But here is where the story takes an unexpected turn. About a month or two after the punch, Gajic received word that his contract with Maricopa County Public Defense Services had been suspended. Nobody called him. Nobody explained it. He just found out it was gone. And on top of that, staff at the office asked him to return the $1,000 he had been paid to represent Payne. Gajic wasn't having it. He pushed back and eventually got them to pay him for the hours he had already put in, $77 an hour for the trial preparation work he had done. But the suspension stayed in place regardless. When ABC 15 asked Maricopa County officials why Gajic had been suspended, they issued a statement saying his contract had been placed on temporary hold because of multiple complaints about his lack of communication with clients, another attorney, and public defense services. Gajic wasn't buying any of it. The timing was too convenient, a contract suspension coming just weeks after he was punched in the face by his own client. He told reporters exactly how he felt about it. "They suspended me from the contract. They never told me why. It's because they're cowards." He filed assault charges against Payne and announced he was going to sue the county on top of it. Now, this is the part that makes this story more complicated than it first appears. The county's own statement about Gajic's communication problems raises a real question. Because Payne's complaint, before he threw that punch, was specifically that Gajic wasn't responding to him, that he was passing him questions, and Gajic was ignoring them. If the county itself later acknowledged there had been multiple complaints about Gajic's communication, from clients, from other attorneys, from the office itself, then Payne's frustration, however wrong his response to it was, may not have come from nowhere. That doesn't make what he did acceptable. Walking out of a courtroom and punching your attorney in the face is never the answer. But it does add a layer to this story that most people who saw the viral video probably didn't think about. Number 5. Obadiah Dillard. On November 15th, 2022, Obadiah Dillard was standing trial for a robbery he had committed 4 years earlier at a Wells Fargo bank in Gainesville, Florida. Now he was sitting in an Alachua County courtroom and things were not going well for him, so he made a decision. He was going to force a mistrial. He was going to do something that would bring the whole thing crashing down before a jury could reach a verdict. What he did next fractured his attorney's skull, knocked him unconscious, and earned him 30 years in prison. Dillard had been in and out of Gainesville's courts for years leading up to November of 2022. His first major offense on record goes back to at least 2009, when he served time in prison for robbing Alliance Credit Union in Gainesville. He later got out. And then in August of 2018, he robbed the same credit union again. That same week, he also robbed 5 other businesses across Gainesville. 6 robberies in 7 days, all committed by a man on a bicycle. He was identified, arrested about 45 minutes after the last robbery. Police found him at an apartment near the Wells Fargo he had just robbed. His bail was set at $750,000. The Wells Fargo robbery itself was bad enough. Dillard walked in wearing a mask and gloves, told everyone inside he was going to blow the place up, tried to steal a wallet from a customer, and then got on his bicycle and rode away. By the time police were looking for him, they already had him connected to everything else that week. He was charged with making a bomb threat, attempted robbery, and assault. And the case made its way slowly through the courts, eventually arriving at trial in November of 2022. His attorney was a man named Eric Atria. Atria had been working as a defense attorney in Alachua County for about 18 years at that point. He worked for the Office of Criminal Conflict and Civil Regional Counsel. His boss was a woman named Candace Brower, who oversees defense attorneys across 5 circuit courts in Florida. Atria was, by all accounts, a dedicated and experienced public servant who had spent nearly 2 decades representing people in that courthouse. On November 15, 2022, Atria was in that Alachua County courtroom, doing exactly what he had done hundreds of times before, sitting beside his client and representing him during trial proceedings. And without any warning at all, Obadiah Dillard turned and sucker punched him on the left side of his head. The punch was hard enough to fracture Atria's skull. It broke one of his teeth, it gave him a concussion, and it knocked him completely unconscious. Atria collapsed to the floor, completely unconscious. The attack did exactly what Dillard had planned. A mistrial was declared, and Dillard was taken back to his cell. And then he made the phone call. From the jail, Dillard called someone and recounted what he had done with what reporters described as glee. He had apparently concluded that the attack only amounted to simple battery. Simple battery is essentially a slap on the wrist. If Dillard was right, attacking his attorney would delay his robbery trial and cost him almost nothing extra. Well, he was completely wrong. The problem was that Dillard had hit Atria a lot harder than he realized. A fractured skull, a broken tooth, a concussion. Under Florida law, that level of injury changes the charge entirely. Simple battery becomes aggravated battery with great bodily harm, and that is a second-degree felony. Dillard had gotten the law completely wrong, and then he had made a phone call from jail, explaining his reasoning in detail, essentially handing the prosecution a confession with a motive attached to it. Atria himself later explained this dynamic in front of the Florida legislature. "Fortunately for me, he cracked my skull right here," he said, pointing to the left side of his head. "He broke this tooth and gave me a concussion. And I say fortunately because had he not done those things, it wouldn't have been a big deal. But because he did, the state attorney's office was able to file second-degree felony charges against him, making it more of a big deal." The case for the attack on Atria was prepared by State Attorney Brian Kramer, and by the time it went to trial in June of 2023, the evidence was overwhelming. There was the video, there were witnesses, there was Atria himself on the stand, and there was Dillard's own jail phone call, in which he had essentially explained his motive and his reasoning. But Dillard, who by this point was required to appear in court via video monitor from a separate room because of his continued disruptive behavior, refused to engage with any of it. He refused to meet with his attorney. He made suicidal statements. He spit at his defense counsel during a pre-trial meeting and was required to wear a spit mask when he appeared on camera. He asked to be returned to the jail and was transported back. The jury deliberated for 6 minutes. Judge David Kreider sentenced Obadiah Dillard to 30 years in the Florida Department of Corrections. Meanwhile, the original case, the Wells Fargo robbery that had brought Dillard to that courtroom in the first place, was retried. In September of 2023, a new jury convicted Dillard of making a bomb threat, attempted robbery, and assault. They also found a mask enhancement, meaning the fact that he wore a mask during the robbery increased his potential sentence further. Obadiah Dillard is now serving 30 years in a Florida state prison for fracturing Eric Atria's skull. The robbery trial that he tried to escape by attacking his own attorney ended in another conviction anyway. In September of 2023, a jury found him guilty on all counts. Whatever sentence came after that was going to stack on top of the 30 years he was already serving. Number 6. LaMarcus Williamson. On October 2nd, 2012, LaMarcus Williamson stood in a York County, South Carolina courtroom and pleaded guilty to assault, robbery, and drug charges. The judge gave him the maximum, 15 years, and then Williamson turned and punched his attorney in the face. Williamson was 30 years old and no stranger to the justice system. He had pleaded guilty to assault, robbery, and drug offenses connected to an attack on a female university student. The full details of what happened to her were never made public, but whatever it was bad enough that Circuit Judge Michael Nettles handed Williamson the maximum sentence available under South Carolina law. 15 years. Now, the attorney standing beside Williamson when that sentence came down was a man named Dan Hall. And here is where the story gets a little more interesting. Dan Hall was not actually Williamson's attorney. Hall was an assistant public defender in York County, a 58-year-old former city municipal judge with 25 years of legal experience. He was in that courtroom that day as a favor to his colleague Mark McKinnon, who was Williamson's actual attorney and was standing on the other side of Williamson when everything happened. Hall had met Williamson exactly once before. He was just there to help cover the hearing. Around 5 in the afternoon, Judge Nettles pronounced the sentence. 15 years, the maximum. And in the moments right after the sentence came down, Dan Hall did what most people would do. He reached over and placed a hand on Williamson's upper arm, just a small gesture. Williamson turned and swung, a full roundhouse punch that caught Hall square in the face and sent him stumbling backward to the floor. Security officers were on Williamson immediately, restraining him and pulling him out of the room. Hall picked himself up, shaken, but standing. Hall ended up with a split lip and a bruise. Speaking to reporters afterward, he said he was not a good boxer. The next day, Judge Nettles brought Williamson back into court for a contempt hearing. Williamson stood before the judge and tried to explain what he had done. He told the judge he was angry because the prosecutor had been trying to make him look bad. "I was upset because the solicitor was trying to incriminate me like I'm some bad guy," Williamson said. Judge Nettles wasn't buying it. He found Williamson in criminal contempt of court and added 6 months to his. Williamson's total sentence became 15 years and 6 months. Dan Hall, for his part, kept things in perspective. He said in 25 years of practice, he had never once seen a client attack an attorney in a courtroom. He noted that Williamson had been handcuffed, still managed to throw a punch with enough force to put a grown man on the floor. LaMarcus Williamson left that courtroom with 15 years and 6 months. The attack had bought him nothing except 6 additional months and a contempt citation. Number 7. Shawn Kennedy. By the time Shawn Kennedy walked into that Washington County courtroom in January of 2013, he had been in and out of jail 22 times in 7 years. The judge knew it. The deputy knew it. Even his own attorney probably knew it. What nobody anticipated was that the next incident would happen right there in the middle of his own trial. The road to that courtroom started 9 months earlier in a church in downtown Bartlesville, Oklahoma. On April 27, 2012, police were called to the Family Life Center at First Baptist Church, right in the heart of downtown. When they got there, they found Kennedy locked inside an office. The victim, one of several pastors on staff at that church, told police what happened. Kennedy struck him in the head and neck with his fists, and then he threw a ceramic lamp at him. When police walked into that office, the place was torn up. Broken objects everywhere. Kennedy was arrested and charged with 2 counts: assault with a dangerous weapon, which was the felony, and assault and battery, which was the misdemeanor. But because Kennedy already had serious felonies on his record, that assault charge carried a lot more weight than it would for someone walking in clean. Under Oklahoma law, when someone commits a violent offense after 2 or more prior felony convictions, the charge carries significantly heavier consequences. Kennedy had those prior convictions. His bail was set at $50,000, and he sat in the Washington County Jail from that April all the way through to his trial in January of the following year. Before the trial, it's worth understanding exactly who Shawn Kennedy was, because this was not a man with 1 or 2 bad moments on his record. According to the Washington County Sheriff, Kennedy had been in and out of jail 22 times in the 7 years leading up to this. His record included threatening, domestic abuse, public intoxication, assault and battery, and assaulting a police officer. His confirmed prior felony convictions include a 2006 conviction for assault and battery on a police officer and second-degree burglary, and a 2010 conviction for 2 separate counts of placing bodily fluid on a government employee. This was a man who had spent a significant portion of his adult life cycling through the criminal justice system. So when his trial finally came around in January of 2013, the stakes were high. His attorney was a man named Larry Monad, an Oklahoma City lawyer who had been appointed to represent Kennedy through the Oklahoma Indigent Defense System. That is essentially the state's version of a public defender system. Kennedy did not choose Monad, he was assigned to him. Monad showed up, prepared the case, and stood beside his client at the defense table in the second-floor courtroom of the Washington County Courthouse before Associate District Judge Russell Vaclaw. The trial was moving on as it should. The prosecution called the pastor, the victim from that April day at the church, to the stand. He sat up there and he testified about what Kennedy had done to him. And somewhere in that courtroom, seated directly behind Kennedy, was Sheriff's Deputy John Zeilinger. Zeilinger had been watching Kennedy all morning, and he told reporters afterward that Kennedy had actually been in decent spirits earlier in the day, right up until that witness testimony began. Something about watching the pastor testify changed things. By the time the pastor finished and stepped down from the witness stand, Zeilinger could already see that Kennedy was not okay. He later said he saw Kennedy starting to fidget, starting to talk to himself. Zeilinger leaned forward. He told Kennedy directly, "Shawn, you need to calm down. You better calm down." The moment Zeilinger reached his hand toward Kennedy, Kennedy lunged toward Larry Monad. His fists were flying. He connected, one punch, right to the face. He also tried to kick Monad, but the kick went into the air and didn't land. Zeilinger tackled Kennedy to the ground before anything else could happen. Judge Vaclaw immediately declared a mistrial and dismissed the jury. As for why Kennedy did it, his attorney was never going to say for certain, and Kennedy himself didn't explain it publicly. But Zeilinger offered what he believed was the most likely reason. He told reporters, "What I'm getting from the time before it happened is that he was unhappy with his attorney." The implication being that Kennedy didn't feel Monad was actually fighting for him, that watching the pastor testify unchallenged, or at least not challenged enough in Kennedy's eyes, pushed him past whatever line he had left. Monad spoke to reporters after the incident. He said he wasn't hurt, and he said clearly that he would no longer be representing Shawn Kennedy. Kennedy was taken back to the Washington County Jail, where he had already spent 9 months waiting for the trial that had just imploded in front of him. The following day, a new assault charge was filed against him for the attack on Monad. He also faced a contempt of court citation. Judge Vaclaw ordered him to return to court on February 20th for a new trial date to be set on the original pastor assault charges. Following the courtroom attack, a mistrial was declared for Kennedy's original 2012 assault charges, and he was subsequently charged with a new count of assault and battery for the attack on his attorney. However, neither case reached a final verdict in 2013 because a forensic examiner found Kennedy mentally incompetent to stand trial. As a result, all criminal proceedings were temporarily suspended, and Kennedy was committed to Eastern State Hospital in Veneta for psychiatric treatment with the goal of restoring his competency. While the attorney he attacked was forced to withdraw from the case, the legal process remained in limbo pending Kennedy's mental health evaluation. Number 8. Christopher Teal. On May 14, 2018, Christopher Teal followed a 40-year-old woman into a portable restroom outside a Volkswagen dealership in Seattle's Ballard neighborhood. She had dropped her car off for service that morning and was waiting for a shuttle to take her to work. She had no idea anyone was behind her. He forced open her stall door, grabbed her by the throat and shoulder, threw her to the ground, and sexually assaulted her, choking her every time she tried to scream. And while he had his hands around her throat, he told her, "You want this. God wants this." 2 employees heard the commotion from the building next door. They couldn't get the door open. It was locked from the inside, so they kept banging on it. That noise distracted Teal just long enough. He backed off. The woman unlocked the door herself and got out. The employees grabbed Teal and held him right there until police arrived. At the police station, he admitted everything. He told investigators he followed the woman into that restroom to assault her. He said he locked the door. And then when a detective offered him a glass of water, he headbutted him. He was charged with first-degree rape and unlawful imprisonment. And what followed over the next 3 years, before he ever faced consequences for any of it, was one of the most chaotic journeys through the court system this series has seen. Before the incident at the portable restroom outside that Volkswagen dealership, Christopher Teal was a 24-year-old homeless man who had moved to Seattle from Texas in 2016. He was 6 feet 3 inches tall and weighed around 250 pounds. And according to everyone who encountered him around the time of the attack, something was clearly wrong with him mentally. Officers who responded to the scene described him ranting that the air was poisonous. Nothing he said made sense. After his arrest, Teal was evaluated to determine whether he was fit to stand trial. The finding came back that he was not competent and could not stand trial. So Teal was sent for treatment. And then he was evaluated again. Still not competent. He was sent for more treatment. Evaluated again. Still not competent. 3 times. 3 separate evaluations. 3 separate findings that Christopher Teal was not fit to face the charges against him. He was eventually sent to Western State Hospital, a major psychiatric facility in Lakewood, Washington, about an hour south of Seattle, for an extended stay. He was there for a full year, and during all of this, things got much worse before they got better. Teal lost over 100 pounds while in custody. Jail health staff described the weight loss as drastic and deeply concerning. He intentionally slammed his finger in a door hard enough to sever part of it, and then he did it again. At one point, the deterioration in his mental and physical health was severe enough that he was forcibly injected with antipsychotic medication. There was also a psychiatric evaluation completed in 2019. While all of this was going on, that added a complicated wrinkle to the picture. The psychologist who examined him concluded that Teal may have been feigning the symptoms of his psychotic disorder. Not that he wasn't struggling, but that some of what he was presenting may not have been entirely genuine. After his year-long stay at Western State Hospital, Teal's competency was finally restored. The case could move forward. By this point, it was 2020, nearly 2 years after the attack at Carter Volkswagen. On February 13, 2020, Teal was brought to courtroom 1201 at King County Superior Court in Seattle for a competency hearing. Teal's court-appointed public defender was a man named Reed Birkland, a lawyer with the King County Department of Public Defense. Superior Court Judge Karen Donahue was presiding. The hearing was underway. Judge Donahue was addressing Teal and Birkland directly. Without warning, Teal turned and punched Birkland in the head. At least 4 King County Sheriff's deputies immediately moved in and tackled Teal to the ground. He was restrained, pulled out of the courtroom, and taken back to jail. The hearing was postponed. What happened next says something important about the kind of person Reed Birkland is. He told reporters he was not hurt. He said he held absolutely no ill will toward Teal. And he said clearly that he did not want any charges filed against his client for the attack. The following day, February 14, 2020, Birkland filed a formal notice of withdrawal with the King County Superior Court Clerk's office. The document stated simply that he was withdrawing as counsel of record for the defendant, effective that date. He walked away professionally and without bitterness. But Teal was not done. 2 weeks later, on February 27th, Teal was back in that same courtroom for a continued competency hearing. This time he was handcuffed, and it still wasn't enough to keep things calm. During the hearing, Teal started shouting. He appeared to move toward the judge. Officers surrounded him immediately and tackled him to the ground again. The judge postponed the hearing and moved it out of courtroom 1201 entirely. The case continued to grind forward. A new attorney was appointed. And then, in November of 2021, more than 3 years after he followed that woman into a restroom at a Seattle car dealership, Christopher Teal pleaded guilty to first-degree rape. On December 10, 2021, Superior Court Judge Sandra Widlin sentenced him to 8.5 years to life in prison, 102 months minimum. The state and Teal's own defense had jointly recommended that sentence. If he is ever released, he will be required to register as a sex offender and will remain under the supervision of the Department of Corrections for the rest of his life. Number 9. Romelo Randall. Romelo Randall had already done everything he could to derail his own murder trial. He caused a mistrial, screamed at the judge, and went through attorney after attorney. Then, on the morning of March 18, 2024, with the trial just days from ending, he did something no one in that courtroom was prepared for. The story actually starts 4 years earlier, in Antioch, California, with a woman named Jonay Bridges. She was 24 years old, living in the Bay Area, and she and Romelo Randall had been in a relationship and had a son together, a baby boy who was just 2 months old when all of this happened. By the summer of 2020, Jonay and Randall had split up, and things between them turned bitter. They were in the middle of a custody dispute over their infant son, and Randall had apparently decided he wasn't going to let things play out through the courts. At around 12:30 in the morning on July 27, 2020, Jonay Bridges was sitting in a parked car in the parking lot of a 7-Eleven convenience store on Buchanan Road in Antioch. She wasn't alone. There was a 27-year-old man sitting with her in that car, and that's when Randall showed up on foot, walked up to the vehicle, and opened fire. Jonay was struck several times and pronounced dead at the scene. The man with her was struck at least twice, but survived and was taken to hospital. When investigators began to connect the dots, it was clear this wasn't a confrontation gone wrong. Randall had put a GPS tracking device on Jonay's car. He had been monitoring her movements. He knew where she was going that night. He followed her to that 7-Eleven and walked up to that car knowing exactly what he was going to do. He was arrested the following day when Antioch detectives and the Oakland Police Department tracked him down in the city. When investigators searched his Oakland home, they found more than 20 firearms, including several assault rifles. Randall was formally charged with murder, attempted murder, shooting into an occupied vehicle, and firearm enhancements. His bail was set at $6 million. Randall was not in this alone. Prosecutors believed he had worked with another man, a 24-year-old named Christopher Slaughter, to plan and carry out the killing. Slaughter allegedly obtained the weapon used in the murder. He eventually took a plea deal and was sentenced to 15 years, but Randall didn't see it that way. His position from the very beginning was that Slaughter was the one who actually pulled the trigger, that he was being framed while the real killer walked away with a deal, and that belief drove everything that came next. When Randall's first trial got underway in 2022, he decided he was going to represent himself, and from the very first day, things started going wrong. During the prosecution's opening statement, Randall interrupted to tell the jury about his own innocence. The judge at the time told him to wait his turn. Randall said he would wait until after the prosecution rested its case. That set the tone for everything that followed. As the trial moved forward, things kept escalating. Randall called his mother to the stand as a defense witness. When the prosecutor, a man named Kevin Bell, started cross-examining her, Randall told his own mother right there in open court not to answer anything Bell was asking. And when Bell kept going anyway, Randall lost it. He started cursing at Bell in front of everyone. And when Judge Birch tried to get things back under control, Randall looked at him and said, "Shut up, I'm not your bitch." Judge Birch had seen enough. He removed Randall's right to represent himself and declared a mistrial. The case was just days away from reaching the jury when it all fell apart. The district attorney's office refiled the case and started again from scratch. This time Randall would have an attorney, not by choice, but because the judge had taken that choice away from him. A series of public defenders came and went. Then in September of 2023, during one of the pretrial hearings, Randall allegedly swung at one of his own attorneys, a man named Lawrence Strauss. But after that, a new attorney was brought in. His name was Matthew Fregge. And Fregge, knowing full well the history of this case and this client, took it on anyway. The second trial got underway with a new judge presiding. By March of 2024, things were in the final stretch. The defense had been presenting its case. The last witness called was Randall's own brother. Closing arguments were expected within days. Everyone in that courtroom thought they were almost done. On the morning of March 18th, court was in session at the A.F. Bray Courthouse in Martinez, the seat of Contra Costa County. Randall was at the defendant's table, physically restrained and chained to his chair. But at some point that morning, without anyone noticing, he managed to cut through or break the restraint keeping him in that seat. He reached over to the defense table, grabbed Matthew Fregge's pen, jammed it into Fregge's head, and then near his jaw twice. He then turned and charged toward Kevin Bell, the prosecutor, who was standing near the jury box. Bell pushed him off and swung back in self-defense. A courtroom deputy tackled Randall before he could do any more damage and brought him down. The courtroom was cleared, and the fire department came to assess both attorneys. Fregge had been stabbed in the face and near the jaw. Bell had nothing more than a scratch on his hand. Both of them refused to go to the hospital, and both of them were back in court the very next morning. What investigators found afterward was something nobody expected. Back at the Martinez detention facility, among Randall's belongings, was a handwritten note, written before the attack. It said one word: sorry. He had known exactly what he was going to do before he did it. Freggie believed Randall didn't stab him out of rage. He did it to force another mistrial to buy himself more time. But it didn't work. 2 days after the attack, on March 21st, the jury came back. Guilty on all counts: murder, conspiracy, possession of an assault weapon, shooting at a motor vehicle. But getting to that verdict wasn't straightforward. One of the jurors who had witnessed the pen attack was so shaken by what he saw that he told the court he was too upset to continue. He was excused from the case. A replacement juror was brought in, and the trial pushed forward. And then, toward the very end of the trial, Randall did something that even by his standards was hard to believe. He looked at the jury and told them that if they found him guilty, he would murder every single one of them. They found him guilty anyway. After the verdict came in, Randall still wasn't done. He filed a handwritten motion from jail, arguing that a life without parole sentence would be cruel and unusual punishment. Judge Shawn Kennedy was apparently unmoved. He sentenced Romelo Randall to life in prison without the possibility of parole. On September 26, 2024, Randall was transferred to North Kern State Prison in California, where he remains today. Number 10. Eduardo Masias. On December 13, 2012, Eduardo Masias walked into a San Diego courtroom with a razor hidden in his mouth. He had smuggled it past the metal detectors, past the pat-downs, past every security check between the jail and that courtroom. And when he decided to use it in the middle of an active trial, he used it on his own attorney. Masias wasn't new to violence. His first run-in with the justice system came when he was still a teenager. In 1995, as a juvenile, he pleaded guilty to voluntary manslaughter. The details of that case aren't public, but it wouldn't be the last time. Years later, in 2007, Masias was involved in the shooting death of a man named Torres. Masias pleaded guilty to voluntary manslaughter again in March of 2010. By that point, he was already in the California state prison system. And it was inside that system where things got even worse. R.J. Donovan Correctional Facility houses thousands of inmates, including members of some of California's most dangerous prison gangs. Masias was one of them. He was a reputed member of a street gang with ties to the Mexican mafia. On July 5, 2010, while Masias was serving time at Donovan for the Torres manslaughter, something happened in the prison yard that would eventually bring him to that San Diego courtroom 2 years later. A fellow inmate named Victor Ortiz had reportedly been pushed out of the Mexican mafia. That made him a target. Prosecutors said the Mexican mafia had ordered a hit on Ortiz, describing the attack as part of a power struggle for control inside the prison. Masias, along with 2 co-defendants, Geronimo Polina and Lionel Quinteros, carried it out. Prosecutors were very clear about what they believed happened in that prison yard. It was not a fight that broke out. Deputy District Attorney Hector Jimenez told the court that Masias had been hiding with a razor, waiting for Polina to bring Ortiz to him. He called it exactly what it was: a pre-planned, coordinated attack. He said they were told to do it, that they had to do it. A prison guard fired multiple rounds to stop the attack before it went any further. Ortiz survived. Masias was charged with attempted murder, conspiracy to commit murder, and assault. All 3 men were charged together. And by late 2012, the trial was underway in San Diego Superior Court before Judge Peter C. Dede. William Bergener, a San Diego criminal defense attorney with 30 years of experience, was representing Masias. The trial was deep into its final phase. The prosecution's rebuttal witness was on the stand. And sitting in the gallery that morning, watching the legal process as part of a class assignment, were roughly 15 to 20 students from Grossmont High School in El Cajon. They were there to learn how a real courtroom worked. What they saw instead was this. Around 10:20 in the morning on December 13th, 2012, Eduardo Masias reached over and slashed William Bergener across the lower cheek with the razor he had been hiding in his mouth. The cut was deep enough to require stitches. Bergener was going to be left with a permanent scar. Bergener was carried out of the courthouse on a gurney with his face wrapped in bandages. Those high school students sat in that gallery and watched a defense attorney get wheeled out of the building with his face covered. The Court Services Investigation Unit began trying to figure out immediately how Masias got that razor past security. Every inmate is searched before leaving the jail. They pass through a metal detector. Sheriff's deputies run a full pat-down, and yet somehow a razor had made it through all of that. The answer confirmed by multiple sources afterward, was that Masias had simply hidden it in his mouth the entire time. Judge Detta recessed the trial. He met with the attorneys and had to decide whether to declare a mistrial or push forward. He told the jury to come back the next morning. And then something happened that even by the standards of this case was remarkable. Despite having a fresh cut on his face and a scarf of bandages around his head, William Bergener told reporters he would be back in court the next morning. He said he would return to represent Masias. He was grateful, he said, that the injury would only leave a scar. The judge made a different call. Judge Dede ordered Masias removed from the case as his own client. Bergener was taken off, and Masias was now going to represent himself for the rest of the trial. So that is exactly what happened. Masias stood up in that same courtroom and delivered his own closing arguments to the same jury that had watched him slash his attorney. He told them there was no conspiracy. He told them he acted alone in the prison yard and wasn't trying to kill Ortiz. "I did what I did for my own reasons," he told the jury. There is no hit list. The jury wasn't buying it. They convicted Masias of conspiracy to commit murder, attempted murder, and assault. They also found that the attack on Ortiz had been carried out for the benefit of a street gang. Co-defendant Polina was convicted on the same charges. Quinteros, the third man, was acquitted of conspiracy and attempted murder, but convicted of assault. In May of 2013, Masias pleaded guilty to aggravated mayhem for what he did to Bergener in that courtroom. Sentencing came in September of 2013. Judge Detta sentenced Masias to 64 years to life in prison, plus an additional 35 years to run consecutive to the manslaughter sentence he was already serving. The judge ruled he was not entitled to any jail credits. He ordered Masias to pay $380 in medical expenses to Bergener and fined him $20,588 to be collected from whatever wages he earned in prison. Polina got 75 years to life, plus 16 years. Quinteros got 8 years. As for why Masias attacked Bergener in the first place, he never said. No public statement, no explanation offered in court. Some observers at the time speculated that he was trying to force a mistrial by removing his attorney mid-trial. Others thought it was simply rage. What we do know is that it didn't work. Whatever he was hoping to accomplish by hiding a razor in his mouth and walking into that courtroom, it didn't happen. He represented himself. He lost. And he is now looking at spending the rest of his life in a California prison. And that is everything we have for you today. If you enjoyed this one, subscribe and turn on notifications so you never miss a new case when it drops. We will see you in the next one.